Okay, I think we're ready to begin. Hello, everyone. I am Anne Bloom, the Executive Director of the Civil Justice Research Initiative and Access to Justice think tank at Berkeley Law. We're pleased to offer today's program, Selection of Leadership in Multi-District Litigation, in collaboration with the Stanford Center for the Legal Profession. We'll get started in a moment. First, I'd like to thank AAJ's Robert L. Habush Endowment for their support of this event and other programming at Berkeley Law. And I also want to introduce Andrew Bratt, Faculty Director for the Civil Justice Research Initiative at Berkeley Law, and Nora Freeman Engstrom, Professor of Law at Stanford Law School and co-director of the Stanford Center on the Legal Profession. Nora, we'll begin with you.
Thanks, Anne. As most on this webinar probably recognize, MDLs now account for roughly half of all federal civil filings, whereas MDLs accounted for just 1% of civil cases in 1991. So MDLs are big, and the question of how to make these cases a site of equity, fairness, and transparency is urgent and demanding of our collective attention and focus. On behalf of the Stanford Center on the Legal Profession, a co-sponsor of this program, I want to thank everyone for being here today to discuss these questions. We've got some of the most thoughtful scholars, judges, and practitioners on deck. I particularly want to thank you, Anne, and the Berkeley's Extraordinary Civil Justice Research Initiative for making all of this possible. Over to you, Andrew.
Thanks so much, Nora. I will simply echo everything that you said, pass along my thanks to you and your colleagues at Stanford for your excellent work in helping us put this very important and timely panel on. It's wonderful to see so many friends, old and new, from the multi-district litigation world, and I'm very eager to learn a lot from all of you. So with that, I'll turn it back over to my colleague, Anne.
Thanks to both Nora and Andrew, also to all of our speakers for taking the time to join us today, and to the audience as well for taking the time on a Friday afternoon here in San Francisco, at least, to join us to think about these interesting and I think challenging issues. I also want to thank our fabulous Berkeley Law events team, especially Julianne Paragas, who's been working very hard for us behind the scenes. Thank you, Julianne. With that, it is time to get started. As you know, we have two panels for today with about 50 minutes for each panel. The first panel will be focused on diversity issues and will run until about 1:55 p.m. Pacific time. We will then take a short break, just 2 or 3 minutes, to set up the second panel, which will begin promptly at 2 p.m. and focus on selection of leadership in light of other aggregate litigation considerations. For each panel, we begin with hearing brief remarks from each panelist and then open it up to questions from the audience, which you can pose using the Q&A feature. The chat function has been disabled. We will wrap things up right at 3 p.m. And if it's not already there in the chat, you will see instructions on how to sign up for MCLE credit and obtain access to the reference materials in the chat. Okay, let's get started. Julianne, will you please spotlight Andre Mura, who is a partner with Gibbs Law Group, where he represents plaintiffs in class action and complex litigation concerning consumers and workers' rights. Andre is also a member of the CJRI Advisory Board. Andre, thank you for serving on our board, and thanks for moderating the first panel. I will turn it over to you.
Thank you so much, Anne, and thank you for having me. There has been increased attention to the issue of inclusivity and diversity in the appointment of lawyers to leadership positions in MDL and class action litigation. That attention has come from the bench, the bar, and academia, and today we're very fortunate to hear a variety of those perspectives from our panelists. Let me introduce them. First, we have Elizabeth Chambly-Birch, a professor at the University of Georgia School of Law, where she holds the Fuller E. Colloway Chair of Law. She's the author of Mass Tort Deals, Backroom Bargaining in Multi-District Litigation. Her teaching and research interests include mass torts, class actions, and civil procedure. She has been a visiting professor at Harvard Law School and won the American Law Institute's Early Career Scholars Medal in 2015 for her scholarship's potential to improve the law governing class actions and multi-district litigation. So thank you for being with us, Professor Birch. We also have Margaret S. Williams, a senior research associate at the Federal Judicial Center in Washington, D.C., where she specializes in empirical research, most recently for the federal courts. She's also an adjunct professor at Johns Hopkins. And among her many publications, she's most recently a co-author of Judicial Adjuncts in Multi-District Litigation, published in Columbia Law Review. And I have to say, Ms. Williams, I loved your bio there. It was 2 words, data guru, and it feels very apt. So thank you for being with us as well. Next, we have the Honorable Karen K. Caldwell, a judge for the United States District Court for the Eastern District of Kentucky. Judge Caldwell is also chair of the Judicial Panel on Multi-District Litigation. Judge Caldwell is a former United States attorney in the Eastern District of Kentucky, and prior to her appointment to the federal bench in 2001, she was a partner in the law firm of Dinsmore and Scholl. Judge Caldwell has received numerous awards, including in 1995, Kentucky's Outstanding Lawyer Award from the Kentucky Bar Association. And in 2010, Judge Caldwell was inducted into the Hall of Fame at the University of Kentucky College of Law. Thank you so much, Judge Caldwell, for joining us today. And last, we have Kalpana Srinivasan, who is co-managing partner at Sussman Godfrey and a member of the firm's executive committee, where she has secured significant victories for her clients in trade secret, antitrust, patent, copyright, class action, and other complex disputes. She represents plaintiffs and defendants in courtrooms across the country. Her most recent representations include serving as lead trial counsel in an entertainment insurance coverage dispute, acting as court-appointed co-lead counsel for a certified class of hundreds of millions of consumers impacted by anti-competitive conduct in mobile chipset sales, and numerous other cases. Thank you so much for being with us today, Ms. Srinivasan. So why don't we start with Professor Birch and Ms. Williams on your presentation, and take it away. Thank you.
Thank you. Beth and I are delighted to be here today and talk about the selection of leaders in MDL proceedings. Before I begin, I do need to say that though I work at the Federal Judicial Center, my comments today are my own, and I am not representing the views of the FJC or the federal judiciary more broadly. So when Beth and I began looking at leadership appointments in MDL proceedings using a database of about 73 products liability proceedings, we discovered 2 phenomena. First, a small group of repeat players were appointed consistently across these proceedings. And second, that the group was overwhelmingly male. Specifically, we found on the plaintiff side that repeat players held about 63% of all available leadership positions. 50 attorneys were named as lead lawyers in 5 or more MDL proceedings. And those 50 attorneys occupied about 30% of all plaintiff side leadership appointments. On the defense side, it wasn't repeat player attorneys, it was repeat player firms. Attorneys from repeat player defense firms occupied about 82% of available leadership roles. And the 19 defense firms occupied 5 or more leadership positions, claiming about 42% of all of these appointments. And as I noted a minute ago, it's not just that there were repeat players, but that these repeat players were overwhelmingly male. In our list of 50 repeat play attorneys, 11 of them were female, so that's about 22%. And this is again in 73 different products liability proceedings. So it was a pretty broad swath of data, and we found a substantial amount of repeat play and a general lack of diversity. The absence of diversity was in part a function of the appointment and reappointment of the same group of male attorneys. To address diversity, you would have to consider then the role of repeat play and why it happens. Generally speaking, repeat play happens first because encouraging private ordering and consensus, judicial methods for selection of lead lawyers favor those who have litigated multi-district litigation in the past. Repeat lawyers know one another, they work together, and thus they're well positioned to take the helm of these different proceedings. Second, judges appointing attorneys for leadership roles stress attorneys' cooperative tendencies, which of course advantages lawyers with pre-existing relationships who have a track record of working well together. And finally, while all civil litigation tends to result in settlement over trial, the emphasis in settlement within MDL proceedings is especially pronounced. And so consensus tends to produce that outcome. Repeat play is facilitated by the leadership selection process known as the consensus method, which allows attorneys to propose their own slate of leadership. And not surprisingly, the same people end up working together over and over again. They just propose the same slate in a slightly different configuration each time. Attorneys pitch to the courts that the proposed slate has the resources to fund the litigation, that they have experience managing complex proceedings, and of course that they all get along. The focus on experience and cooperation is supposed to facilitate settlement, which, as I noted before, typically tends to be the outcome of MDL proceedings. While the experience of MDL leaders is clearly important, weighing experience and consensus so heavily over other criteria has significant downsides. And among the downsides, of course, is a lack of diversity in MDL leadership. Breaking into a network is hard for outsiders for a number of reasons, especially the financial ones. And we know from other studies, such as the ABA, that even female partners don't make the same amount of money as their male partners, making it more difficult to harness the resources necessary to fund this kind of litigation, and having the funding available is a precondition for leadership appointments. So there is a general lack of diversity among the appointments that we studied, and the methods of selection tended to facilitate the appointment of repeat players who were, generally speaking, not diverse. In updates of our original work, other scholars and legal journalists found some modest improvements in diversity, but this didn't hold across all groups. One study examining gender diversity found modest gains over time. Dana Alvari looked at gender diversity in MDL leadership, and she found some modest improvement. Prior to 2015, female attorneys were between 9 and 17% of leadership appointments, depending on kind of the level of the leadership and the year. After 2015, the percentage of women was much higher, between 19% and 33%, but women were still more likely to be appointed to the lower ranked leadership positions within an MDL proceeding. Another examination of leadership by Amanda Bronstadt, a journalist, looked at race and ethnicity and found very low levels of diversity among MDL leadership appointments. It rose from about 4% of non-white attorney appointments in 2016 to 7% by 2019. But of course, we're talking about very few individual people here. It was only about 19 lawyers. Both studies, both the Alvari study and the Bronstadt study, point to modest gains being made through a more competitive selection method of leadership appointment. Though, as Beth and I noted, competitive selection doesn't necessarily solve the repeat player problem, because the repeat players all just vouch for each other in the competition. And of course, mandates by judges leading proceedings can increase diversity. When judges tell attorneys in MDL proceedings that they want to see a diverse slate of candidates in leadership, the slates are more diverse. And when the pool for selecting leadership is broader, the possibility of finding more diverse attorneys to appoint is, of course, greater. Whether it's appointing new attorneys to leadership so they can gain experience and kind of work their way up the ranks of a leadership structure, or creating mentorship programs to provide opportunities for attorneys interested in MDL practice, who are interested in MDL practice, who want to find a path in, the active participation of transferee judges is seen as key to overcoming the barriers to participation for attorneys who have historically been kept out of leadership. And the role of transferee judges for increasing diversity cannot be understated here. Actively monitoring leadership appointments, reviewing applications, and I think Beth and I would argue monitoring the performance of the leaders chosen would benefit both the proceeding and the litigants involved. And not just by seeing more diverse attorneys serving in leadership, more demographically diverse attorneys serving in leadership, although that is a part of this, it is an important part of this, but also we need to create cognitive diversity in the leadership appointments. Cognitive diversity, which is generally attributed to Scott Page, means people with differences in perspectives or information processing styles coming together to solve complex problems. The different perspectives help create better outcomes because it encourages dissent instead of stifling it. When you put the same people together to solve a problem, you end up with remarkably similar solutions. And Beth is going to talk about that in just a minute. And looking at the settlement provisions and MDL proceedings, when the P players perform together each time, you get remarkably similar outcomes each time. But it's more than just the similarity of the outcomes here. Just as in other areas of public life, where repeat players with expertise are informing the decision makers who are generalists, who are just informing the decision making of generalist policymakers, or here in this case, judicial decision makers, there's the possibility that the advice that's given and the suggestions that they make serve the interests of the people with the expertise, possibly more than the people that they're representing themselves. And while people working in the space of MDL appointments and MDL outcomes and MDL leadership have long wondered about the feelings of plaintiffs over the outcomes that are achieved by repeat players, we began to ask plaintiffs how they're feeling about the litigation that's going on and the outcomes that they're getting. And so I'll turn it over to Beth to talk about those things.
Great. Well, I want to echo Margie's thanks and having us. We're delighted to be here and to present some of our older research, but also some of the newer findings that we've had. So as part of our previous research that Margie just talked about, we also examined all of the publicly available private settlements within the data set. And here we found kind of a unilateral departure from what we tend to think of as a typical settlement between a plaintiff and a defendant, because the settlements that we were examining are all settlements between the defendants and the lead plaintiff's lawyers, where the plaintiffs themselves give up their right to sue to enter into a settlement program that may or may not ultimately compensate them. So I'll sort of tell you a story about the Propulsive litigation. It'll give you a little bit of context for some of the numbers that I'll give you on the settlements, and then I'll talk about some of our newer research. But back in the 1990s, for those of you who have been around a while, you might remember Propulsive. 30 million people took it for heartburn. Johnson & Johnson marketed it to pediatric hospital units for use in kids with acid reflux. Problem, of course, was that the FDA had never approved its use in children. And Johnson & Johnson eventually withdrew Propulsive from the market entirely in July of 2000. The judicial panel on multi-district litigation centralized all of those cases in front of Judge Fallon in New Orleans. Judge Fallon denied class certification. He granted summary judgment on some of the individual cases. But Propulsive is important for us because its leaders at the time pronounced that they were creating a template for all future litigation. And they were absolutely right. What we found is that the settlement provisions that I'm about to describe get replicated and refined by these repeat players and all of the subsequent settlements within our data. So of course, Propulsive's deal makers wanted to maximize closure. So they said, well, if 85% of the death claims don't enroll in this program, then the deal is off. And so we tend to refer these to these as walkaway provisions. And 100% of the deals within our data set included walkaway provisions. The second thing that Propulsive deal makers did is they designed a so-called opt-out form for non-settling clients. But this opt-out form isn't authorizing them to opt out of the settlement. Instead, it's actually authorizing counsel to withdraw from representing the client, meaning that clients are opting out of their attorney-client relationship. So that becomes a template for more sophisticated provisions requiring attorneys to recommend the settlement program uniformly to all of their clients. 84% of the deals that we examined included these recommendation provisions. And then to take steps from withdrawing non-settling clients. And a little over half, 53% of the deals included these withdrawal provisions. So the medical records then go to a panel of doctors who permitted or denied the claims without any explanation. And out of a total fund of somewhere between $84 and $105 million, only 37 of 6,012 claimants were deemed eligible for relief. So that's 0.6%. $6.5 million went to those claimants in total. And the lead lawyers negotiated $27 million directly with Johnson & Johnson for themselves in attorneys' fees and costs. So 84% of all the settlements that we examined, the lead lawyers negotiated some aspect of their fee with the defendant. And of course, bargaining for your fee with your opponent is a really stark departure from traditional contingency fee principles, which are supposed to align lawyers' fees to their clients' fates. So of the rest of the money, 8.3 million goes to Canada, 8.3 million goes to the Louisiana Health Public Initiative, and the leftover funds, some $40 million, reverted back to Johnson & Johnson. So 23% of the settlements that we examined included these reverter clauses. So our worry then is that looking at these settlements that occurred over a 14-year span, we were unable to find any that didn't feature at least one closure provision for the defendants. And we also found that nearly all of the settlements included some sort of provision that increased the lead plaintiff's lawyers' common benefit fees. So simply from looking at kind of these procedural inputs, we found some reasons to be worried that as the repeat players tend to influence practices and norms, they might undermine plaintiffs' ability to freely consent to the settlement which may or may not affect substantive outcomes. So Propulsive was unique in the sense that we were able to get data on the money that was distributed to the plaintiffs. So fast forward to several years. This past summer, we finished a 2-year study that surveyed plaintiffs and MDLs. We asked them things like whether they were satisfied with their lawyers, how they felt about the litigation process, and what they thought about their outcomes. Although we didn't ask, obviously, for information about their actual outcomes, since those were also often included confidentiality provisions. So unfortunately, we found that litigants' experiences confirmed our worst intuitions. I think perhaps the most startling data that we found is that only 1.8% of all of our 217 participants indicated that their lawsuit achieved what they hoped it would. So of the subset of those who settled, only 5% were somewhat or extremely satisfied overall with the settlement process, versus 81% who are extremely or somewhat dissatisfied. And some of this dissatisfaction seemed to sort of stem from information exchange deficiencies on both sides. So from the plaintiff's side, they appeared not to receive a whole lot of information from their attorneys, even information that's required under the model rules of professional conduct. So less than half had an estimate of their approximate award before they agreed to settle. Fewer still understood whether their claims would actually qualify for any settlement money, what their lawyers' fees would be, how much money they would receive versus how much others in the aggregate settlement would receive, and how costs would ultimately be shared and apportioned among all the different clients. So on the flip side, only 16% felt like they had a chance to tell their side of the story during the settlement process. Which of course, I think raises important questions about whether settlement allocations are accurately reflecting substantive outcomes. Of those who settled, 75% felt like their compensation was much lower than they expected that it would be. So how does all of this translate into leadership? Well, collectively, the participants were represented by over 295 different lawyers. 54% of those lawyers were actually lawyers that served in MDL leadership roles. So we're not talking about just kind of a few outliers. We're talking about kind of a more systemic problem. So diversifying leadership slates is a start, but we have a couple of other ideas that we hope might help improve representation overall. So first, I'd just like to quickly say that we'd really love more data on outcomes and access to plaintiffs. So in conducting this study, we contacted over 40 lawyers to try to ask for their assistance in distributing the survey. And we got the sense that nobody really wanted us to do this research. A lot of plaintiffs told us over the phone that they didn't feel comfortable talking with us about their case because their lawyers had told them not to talk with anyone about it. So we'd also echo here Professor Engstrom's recommendations in the settlement mill context for mandatory public closing statements on both fees and recoveries. That could give us a much more robust picture of the entire MDL. So second, we've seen a lot of online conferencing tools. Obviously, we're in an online conference right now. So given the public's newfound familiarity with these types of Zoom hearings and things like that, it's easier than ever for litigants to be able to watch and sometimes even take part in proceedings that are thousands of miles away. So we'd really encourage MDL judges to make use of this technology to allow for geographically dispersed parties to be able to watch the hearings and the bellwether trials firsthand. At certain points, they might even be allowed to participate and to add dissent when dissent is warranted. So third, we'd love to give the plaintiffs themselves an opportunity to evaluate individual and lead lawyers' performance. As Jeremy Bentham observed a long time ago, the more strictly we are watched, the better we behave. And so, of course, courts appoint leaders in part to make sure that the information flows from the leadership committee down to individual counsel, down to the plaintiffs themselves. But neither the lead lawyers nor really the individual lawyers have sufficient incentives to communicate effectively with the plaintiffs. So once there's a deal that's on the table, the lawyers have powerful financial motives to encourage all the eligible claimants to sign up. As Professor Bratt and Teddy Rave have put it, the lawyers at that point are in, quote, sales pitch mode, not counseling mode. So if the court actually sent attorney performance surveys to the plaintiffs, it would give them a meaningful opportunity to provide some feedback. Those results could then factor into things like common benefit fees, since after all, at the heart of quantum merit, which is common benefit fees basis, quantum merit is asking how leadership's appointment has actually benefited the plaintiffs. We also would hope that the results could play a role in selecting future leaders, so long as judges are including the evaluations publicly on their docket. Finally, and I'll close with this, but given the diversity among the clients themselves, the differences among injuries and exposure, et cetera, we'd really love to see judges considering adequate representation when appointing lead lawyers. So thinking about some of the plaintiffs' differences up front, as well as the litigation progresses, can really help build in some due process safeguards and help clarify leaders' fiduciary duties, not just to their own clients, but also to non-client plaintiffs. So I'll stop there and we'll look forward to the discussion.
Thank you very much, Professor Birch. And now we'll turn to Judge Caldwell.
Thank you very much. I thought primarily today that I would talk about the importance of diversity in leadership, and the comments that I've just heard are a little broader than I had been prepared to address, but I'll do the best I can to try to include some of the points mentioned by my predecessors. I think it's very important for us to put this discussion in context. Currently pending, there are 185 MDLs pending on the MDL docket. And we're talking in this context largely about products liability cases. 1/3 of all pending MDLs are products liability cases. That means we're talking about 60 to 65 MDLs currently pending in the products liability or mass tort category. Of those 60 cases, only 16 of those cases have more than 1,000 cases involved. Now, one of them has skewed all the statistics. It is the 3M earplugs case, MDL 2885. It has 235 cases and literally skewed all of the federal civil caseload statistics for the calendar year 2020. So I think it's very important that we consider the number of MDLs that are currently pending. And at 185, that is the lowest number of MDLs pending since 2004. In 2019, the MDL panel centralized 8 products liability cases. And in 2020, the panel centralized 6 products liability cases. Now, why is that important? I think it's very important because what we see are fewer MDLs with more cases contained within them. I can certainly understand why plaintiffs' lawyers are anxious to have an opportunity to participate in this area of the law, and that there are fewer opportunities for many of them to develop expertise in this important area of law. Now, keep in mind that defense lawyers are not appointed by the court, they're chosen by the clients. So I'm talking primarily about plaintiffs' lawyers. Now, I'd like to just take a moment also to talk about MDL transferee judges. There's a big shift in the kind of judges who are handling MDLs. I think for a long time, a lot of judges developed expertise in certain areas and the panel assigned cases to them repeatedly. In 2010, 17% of judges assigned to MDLs had never handled an MDL. In 2020, that number rose to 50%. Now, understand that much of this depends on whether the prior MDL experience is particularly relevant, but at the panel, we want to develop a deep bench of diverse judges. And speaking of that, One of the things that we have focused on is trying to be sure that judges throughout the country, not just in major cities and coastal locations, have the opportunity to develop expertise and to share the burden of it, the extra work for which the judges receive no extra pay or any additional resources. But in 2020, there was the greatest amount of diversity among MDL judges. We had 26 women, nearly half, and 9 people of color. 34% of judges appointed were more diverse. And this compares favorably to the overall diversity of the federal district court bench, which in 2020 was 28% women and 21% people of color. And I believe that those numbers are only going to improve as the current president has dedicated himself to making sure that there is more diversity among federal judges. So I believe that the diversity of MDL judges will necessarily follow. I was looking at primarily at the period of 2017 to 2021 in terms of trying to figure out what are transferee judges doing in terms of appointing diverse transferee judges. And I looked at some cases in the last 4 years in which diversity was specifically identified in terms of gender, race, geography, and experience as specific leadership criteria. There were 7 cases, and as you might expect, these are more recent cases and they are extremely large cases. Again, as I said, there are 16 MDLs with over 1,000 cases in them, and 2 of them have a large number of cases, particularly as I mentioned, the 3M case. What you have to remember also is that in some MDLs, there's no need for the appointment of leadership because the MDLs have so few cases in them. That's not typical of a products liability case. That occurs mostly in the antitrust or patent area, where an MDL may include a handful of cases. But in these 7 cases that I looked at, and in court, that's the Zantac case with Judge Rosenberg in the Southern District of Florida, and the 3M case with Judge Rogers in the Northern District of Florida, they held extensive interviews with applicants for leadership. I think that Judge Rogers had 160 applicants for various leadership positions. She narrowed the field to 60 people whom she interviewed or had make personal presentations with respect to their ability and basis for being appointed to leadership. And among the things she considered, and almost all judges consider the things that are mentioned in the manual for complex litigation, but Judge Rosenberg and Judge Rogers identified geographic opportunities, experiential opportunities, race and gender as specific criteria for appointment to leadership positions. All judges, as I said, overwhelmingly apply all of the criteria in the manual for complex litigation and, of course, the rules for class actions. Now, I think judges are only recently turning more toward these explicit statements in their orders. And I'm happy to see that diversity of experience, gender, geography, and all sorts of things are being considered. It's more difficult, and I believe that Professor Birch pointed this out. Lots of times judges are operating from a proposed slate of leadership candidates. So the plaintiffs parties have all gotten together and they have made a suggestion to the judge as to who should be appointed. And of course, many of the more, what I'll call them the usual suspects, are going to have be well qualified for leadership positions. But I examined about 60 cases in which diversity of experience, gender, and race were not explicitly addressed in any court orders, but they were implicit goals in the judge's selection of leadership. For example, in MDL 2985, the Apple App Store casino games case, Judge Devia reviewed the initial submission slate for the leadership team, and acknowledging that 30% were women, He asked the proponents to report on their efforts to hire and appoint members from more diverse backgrounds and races. Also, in the Jewel Labs marketing case, MDL 2913, Judge Orrick not only expressed at his case management conference that he wanted racial and gender diversity, but that meaningful work be equitably distributed among the participants in the leadership team. And finally, another example is the 2887, the Hills Pet Nutrition case. Judge Julie Robinson in Kansas not only demanded diversity in terms of race, gender, and experience, but she sought divergent views regarding the proper scope of the MDL. So I think this is something that MDL judges are cognizant of. We address it in mentoring MDL judges. We address it at our training conferences. I think it is something that is growing among judges. And again, I found about 60 cases that I just looked at randomly, and where the judges either in their scheduling conferences or in other documents had indicated that these were implicit criteria that should be considered in appointing leadership. I think that judges are also concerned, and what I'm going to call it is inside baseball. I think Professor Birch mentioned this too, where repeat players occupy the field and they don't allow for growth and opportunity. I feel the same way about leadership as I do about the experience of transferee judges. We need a depth and diversity of experience, but we need to provide the opportunities for people to develop that experience. And if the same players occupy the field all the time, that's not going to happen. I'm from a basketball state, and what I like to say is you can't play seniors all the time. You've got to develop a deep bench. But I hope that I have covered everything that you'd like to hear. I think a couple of other tools that judges are using are some disclosures regarding third-party finances. I think that judges are also using initial census as a way to help develop the leadership team, and any other tool that we can. And you've got to remember, we're looking at this from the outset when we're assigned an MDL case, that what can we do to investigate the needs of the case? And we do have to match the needs of the case to all the various criteria that we consider in appointing leadership. Thank you very much, and I'll be happy to take questions at the appropriate time.
Excuse me 1 second here, Andre. I just wanted to interrupt to say that we are experiencing some technical difficulties, and we have to ask Judge Caldwell, if possible, to please unspotlight yourself. Thank you so much for those wonderful remarks. Thank you so much. Back to you, Andre. Apologies.
Oh, no, thank you. Thank you, Anne, and thank you, Judge Caldwell, very much. And now for the practitioner's perspective, we will turn to Kalpana Srinivasan.
Thank you, and I really appreciate Berkeley and Anne putting together this presentation on this important topic near and dear to my heart as a practitioner and as a diverse lawyer who practices in this space. We've heard a lot of the important work and studies that have been done, and certainly whatever the statistics are for women who are seeking MDL appointment, they're even more stark for diverse lawyers who are seeking to do so. It was something like 9% of MDLs over a 5-year period were headed by diverse lawyers. So there is a multifaceted problem, and I know that Ms. Birch and Ms. Williams talked about diversity and other axes, which is important as well. I want to focus a little bit on what happens at the ground level and what I have seen changing and what I hope will continue to evolve with the greater focus on this issue. There has been, of course, the general perception that you need to have leadership that already has substantial experience, and that the court will be most comforted by having a slate of leaders who have done a number of MDLs already or who have deep experience in this area, because it will make the job of the court easier. That is certainly true in some respects, but I think there's a growing recognition that it's not so simple to make that determination about who is qualified or who has the requisite experience, and that it's not just a numbers game. The fact that you have done X many MDLs before doesn't necessarily mean you have every skill set to best position you for this next MDL, which may be in some different subject matter area or may involve different issues. And one of the things that I think has been important, and we talked about considering experience, is not conflating the experience of being able to handle and manage complex litigation with the ability solely to have done MDLs. And that's where I think one piece, an important shift, has to continue to come. I can speak from my own perspective that my first MDL leadership appointment came in an area in which I had a lot of subject matter expertise because I do non-MDL and non-class work as well. I do a lot of intellectual property work. And so there was a very useful intersection of some of my other experience that the court focused on in granting my appointment. I also tried a case in that court before, and nobody else seeking appointment had done so, and that was relevant to the court. And I say all that again because I do think it should be a focus in appointments to look at these assorted metrics in figuring out what really makes somebody have the ability to take on a difficult case. And it is not simply just, again, that they've done it 10 other times. The issue of the repeat player problem creates, again, both the perception that that is how a slate should come together, and also a roadblock for emerging lawyers. Look, there are a lot of female and diverse lawyers who are out there doing the hard work of the MDLs. They are in the background. They are handling the difficult depositions. They are working on the briefing. They're analyzing the issues. They're putting together these cases top to bottom. But if the perception is that only the people who have been appointed leaders before should be the ones who are named leaders again, then of course it's very difficult for them to advance and to be able to be considered as a leader. The other issue, and this is something of course endemic to our profession, is that in a complex case, in an MDL, in a high value case, it is difficult to say that a diverse or female lawyer should be in the lead if they are also not holding some type of role within their firm, meaning that they have to have the ability at their firm to command money to support those types of cases, including expenses. And I'll talk a little bit about litigation funding in a minute, but they have to have the ability to garner the firm's support. So, naturally, it is usually partners at law firms, big or small, who are standing up as and seeking leadership positions in MDLs. So to be able to better position themselves to be considered for leadership, that is an important part of the process, in my view. Plaintiffs' firms and firms that are interested in handling plaintiffs' work need to make sure that they themselves are diversifying their ranks, training and developing lawyers so that they are advanced enough that they're natural selection to take on those leadership positions, and that they can go to their firm and say, I'm asking you to devote all these resources to it. They need to have that credibility and have that clout within their firm to do it. So there is work to be done both in the appointment process, but I think even a few steps behind that in the plaintiff's bar itself, in the retention and recruitment of diverse and female lawyers, and making sure that they elevate so that they can be part of the decision-making and be part of putting together the panels and the slates and have a chance to be able to throw their name into the mix. One of the things that Judge Caldwell talked about, some of the really significant recent appointments that have taken place. And I can add more to the mix. I know in South Carolina that Judge Childs put together a slate in a data privacy MDL that she described as the most diverse leadership slate in the country. And she said that it was very important to her that was critical in assembling that group. And part of what it also meant was looking at a different generation of lawyers, younger lawyers, frankly, younger partners at law firms, younger lawyers who are coming up the ranks to be able to do that. And I think it had a really powerful impact to see these orders coming out, to see judges saying it's what they want. It's been a bit of a chicken and egg problem. If you have a bunch of lawyers saying, look, we need the top people who have always done this to come together to maximize our chances of being selected by the court. And then you need the court to come back and say, well, actually, it's okay. We want to see, and we feel the need to help cultivate other lawyers who are going to step into this role. So we don't need this, the top lawyer who's done every MDL, who's probably already handling a bunch of other major class actions to be the person who is appointed here. We want to see somebody who is going to have the requisite qualifications, but who hasn't gotten the opportunity before and who reflects some of the diversity that we're trying to establish in leadership. And I think it's been critically important to have the court say this unequivocally, because I think it is just too easy for lawyers to say, well, this is what the court wants, so we have to do it this way, or to try to presume that that's what's going to influence their ability to be selected. And candidly, it happens on the defense side. It happens with corporate clients. You hear people say, well, I don't think this corporate client will ever support us having so-and-so try their case. And a lot of times it's simply not true. It's not true that those clients are unwilling to have different types of lawyers represent them in court. And it's likewise not true that judges are unwilling to have a different set of lawyers representing a class, as long as they have the ability to manage it. And the truth is, some of the younger lawyers who are doing that, who are diverse, who are women, they may have one appointment. They don't have 5, 6, 7, 8, 10. And so they are able to actually devote a lot of their energy and resources to ensuring the successful advancement of those cases. They understand that they have been given a very serious responsibility, especially if you have a personal appointment. And they are not going to take that lightly. It would, especially if you've been given your first shot to do so. If you fall down on the job, that is going to have a career and professional reputational impact on you. So I think it's a bit of a misconception that if you entrust that to somebody who hasn't done one before, that they're not going to be able to handle it. And many of them do come from firms where they have access to more senior lawyers that they can ask for input or insight for if there's some issue they haven't faced before, as is true in any litigation. So to me, that has been, frankly, one of the most important developments in this space, is having the court say, I want it this way. I don't simply need to have the same people. And it's also, and I think to Judge Caldwell's point, even where it hasn't been explicit and where it's maybe quietly expected, it's changed some of the negotiations and discussions within the plaintiff's bar. I think that 5 or 10 years ago, it wouldn't necessarily be the case that people would think about that in private ordering. Do we have diverse representation? Do we have women represented here? Even if it's for their own interest in making sure that their private ordering will be accepted. But I do think that sense is there now, that whether it's part of a formal court order or just a general sense that that is anticipated of the leadership slate, it has changed those conversations. It has changed what people do when they're discussing working together and forming teams, maybe more senior lawyer working with a junior one, 2 junior ones working together. It is opening up the mentality about what that slate looks like. So I think that's been extremely influential. The economics of these cases, as I referenced earlier, can play a very significant role. They're expensive. They require upfront costs, hard costs. They require a lot of the ability to involve many people who can work at it at your firm. And I saw somebody had asked about litigation funding. I do think that having a process, a governed process for how litigation funding can be used, and how it should be disclosed, would allow some lawyers who might not otherwise have the wherewithal or be able to get the finances together to participate, but to do so in a way where they felt it wouldn't be, they wouldn't be penalized for it, just because maybe some other lawyers didn't need to do it. And so that is something I think there should be more discussion and development around. It is a significant barrier to entry for a lawyer who doesn't have the established means to enter some of these cases that are very costly on the front end. And finally, I would say that, I'm always cognizant of how important it is to get beyond perhaps the notion ever of people being tokenized. And that is true in any aspect of our field. It is really important to see MDL leaders truly be given the role of leaders. They are the people deciding settlement. They are the people making the key strategic decisions in the case. And so they should be diverse, they should be women, and they should be expected to do that and what I don't want to see is somebody who is appointed, but who at the end of the day still may have involved, or there may be an expectation that any major decision is not done by them, but by somebody else who is at their firm who didn't seek the appointment. We need to continue to work on that and to help build that network among other lawyers so that they are the decision makers and leaders as they need to be going forward. And I'm happy to participate in any other questions that the group may have. Thank you.
Thank you so much, Kalpana. I'll add just a couple of practitioner other observations, and then we'll move on to questions. And if you have any questions, please feel free to add them to the Q&A box. But I wanted to bring up two barriers to entry, and it echoes a lot of what Kalpana was talking about. One barrier to entry is that courts that consider individual leadership applications often either do not receive or do not accept more than one application from a single law firm. And that is a barrier to inclusiveness and diversity in the following way. There is more diversity among younger attorneys. And in as much as those attorneys end up at the same law firm, which is often the case because no one wants to be the token person, a diverse person at a single law firm, the court should be welcoming rather than not allowing those applications from individuals at the same firm. Otherwise, what happens is you have a dynamic, and Kalpana talked about this, where younger attorneys, diverse attorneys must wait in line and work in the shadows, and they're not being publicly recognized. And ultimately, they lack the ability to gain that first appointment, which, however small, helps achieve future appointments. So again, I think relaxing this rule would allow for more diverse applicants. It would also mean that younger attorneys who are diverse, who work on the cases anyway, would get their just due. And the response to this proposal often is a concern with overbilling or overstaffing. But again, those younger attorneys are working on the case anyway. And if billing is properly managed and the number of hours are properly managed, the work should be the same. The difference would be that you'd have a more diverse slate of attorneys receiving some recognition, receiving experience, and their just due, which is incredibly important to them, especially to maintaining and starting a complex litigation practice, which is difficult to maintain if you're just not getting a series of appointments. And the second point I wanted to make is that there's a difference between being appointed to an MDL and actually working on that MDL. And oftentimes, a lot of the academic literature focuses on the appointment process, but I haven't seen much academic literature or study about reappointments. And there oftentimes isn't in MDLs a reappointment process. And if there is, it's pro forma. But if we value diversity, we should also value and scrutinize whether counsel is effectively discharging their leadership responsibilities, which should include the equitable distribution of work among younger, diverse attorneys. And Judge Caldwell mentioned this as an important consideration that judges are looking at, whether meaningful work is being distributed. And I echo that. I think that that's quite important to advancing diversity among the bar in MDLs. And so now we have a few questions. Why don't I turn these over to the panel? The first comes from, I believe, Professor Richard Marcus. Is access to third-party litigation funding important to diversifying leadership appointments? Would requiring detailed disclosure about that funding have a positive impact?
I sort of preemptively shared my views on this, having seen Professor Marcus's question. And I know there's also a follow-up question about whether some funding itself is more available to repeat players. And I think that is also an issue, because Many funders look to counsel that they know have a certain reputation when determining whether it's appropriate to extend funding and their own risk analysis. So I do think those are issues, but I do, again, if a court had a protocol for doing that, it might make it more widely available to a broader swath of lawyers.
I just want to jump in and apologize and say we are continuing to experience some technical difficulties. We are attempting to spotlight all of the panelists at this time for some discussion, and we'll probably run over a few minutes just as we have been trying to deal with the technical difficulties. It's being caused by problems with internet connectivity in Berkeley. Thanks.
All right, thank you. Why don't we move to another question, which for the academics, hopefully. The literature includes fewer studies and much less data on diversity when it comes to LGBT lawyers than women in general. But the studies that are available, they pretty clearly show that LGBT lawyers are more underrepresented than women. Are you familiar with any increased academic attention to this area? And can you talk about if there is any increased attention to this area, what those studies are showing?
Hey, Andre, this is Beth. I'll jump in here. You know, I think so the easy answer is no. We haven't seen a lot of work being done in that area. You know, I think what's hard about it is the same sort of thing that's difficult about the you know, questions about minority representation, that you really have to call and get people to respond and get people to answer and get people to divulge that information. It's not something that you can easily tell by looking at people's profile picture. And so, you know, I think the response rate is sometimes difficult.
Thank you for sharing that. Judge Caldwell, you talked about the importance in Judge Rogers in 3M litigation, how she met with so many attorneys in the appointment process. If you could give some advice to a younger, diverse attorney who does not have a lot of contacts in the field, how they might present an application to you that might sort of grab your attention and allow them to sort of advance. Is there something in particular, some advice that you could share from the judicial perspective?
Well, I think it's very important for us to examine and to value diversity of experience. If you've tried 100 cases and they're all the same DUI cases, does that make you a better trial lawyer than if you had tried 3 mass tort cases? So I think we have to compare experience on realistic terms. Someone who has subject matter experience, youth, and energy might be more valuable than someone who's done something 10 times poorly. So I think that you need to look at the quality of experience, the nature of the experience, and energy in terms of how a person is willing to apply that experience. I think possibly I would want to see in an application, maybe even some proposed ideas for managing the case at hand. And as you know, in each case, they're also different. So it would have to be targeted to the needs of the particular case. And one of the things that I would like to see, and to answer Professor Birch's concerns about this, is how do you, as lead counsel, intend to keep your clients informed? Will you set up a website? Will you send out newsletters? Will you work with the courts in terms of facilitating communication? I have to tell you, the first time I ever heard someone refer to their clients as their inventory, I was aghast. I'd never in my life imagined that any lawyer would ever refer to the people that they represent as inventory. So I think that one of the things, I believe that Judge Rogers has done this. I know Judge St. Eve did it in a case. Several judges are appointing people to leadership for a period of 1 year. It holds them accountable. And at the end of that year or throughout the course of the year, they expect status reports In other words, show cause why you should be appointed to stay, providing another opportunity for someone who is energetic to replace those who are not keeping their clients informed or doing their jobs. And, you know, again, in 2020, there were only 6 appointments of leadership in mass tort cases. That's not a lot of opportunity. The cases were bigger, so the leadership choices that we make are more important. So I think that's what I would want to see from a young lawyer. And, you know, I'm not sure I really understood the question or the comment that someone made about members of the same firm not being able to apply for separate leadership positions. Of course, any of us who've worked in a law firm know that partners took credit for all the work we did for years. And but I do think that you'd have to be real careful about that, because you might have a big firm or an inside player have all of their associates make an application in hopes that one would bring a ringer for the team. So that would be my only concern about that, if I understood that question properly.
Okay, thank you very much. Well, I believe we're out of time, so I wanted to thank Judge Caldwell, Professor Birch, Margaret Williams, and Kalpana Srinivasan for participating today. Thank you all for your insightful comments.
Thank you, everyone.
Thank
This is Ann Bloom from Berkeley Civil Justice Research Initiative. We're going to transition now to the next panel. I will ask the first panel to please turn off your videos and mics, and ask the second panel to come forward. We're going to transition as quickly as possible because of the technical difficulties we've been having. We're running just a little bit over. It looks like almost everybody is here. Yes, I think we have everyone, so we're going to move on immediately. Thanks again to everyone for your patience. I think we're solving the technical problems. We really apologize for the difficulties with spotlighting. So welcome to the second panel, selection of leadership in selection and leadership in multi-district litigation. This panel will focus on selection of leadership in light of other aggregate litigation. Our moderator for this panel is another Civil Justice Research Initiative board member, Jocelyn Larkin, Executive Director of the Impact Fund. If whoever is currently solving the spotlighting problems could please spotlight Jocelyn. Thank you so much, Jocelyn. Hopefully you are out there. We will turn it over to you. Thank you.
Okay, no, I'm ready to go. Thank you so much, Anne, and I'm excited about this next panel, and particularly building on what we just got to listen to, which was fascinating. So as Anne mentioned, I am the Executive Director of the Impact Fund, and for those of you who don't know, we are a legal nonprofit in Berkeley that supports social justice impact litigation through grants, training, and litigation. Let me quickly introduce our panel, because I do want to get to them so they can get us started. So our first speaker you've already met, Nora Engstrom. She's a professor at Stanford Law School, and her scholarship focuses on the tort system and legal ethics. We are very privileged to have Judge Robert Dow, who sits on the Federal District Court bench in the Northern District of Illinois. Judge Dow is the chair of the Advisory Committee on Civil Rules, which is right now studying the MDL process and considering possible modifications to the civil rules. We are also joined by Professor Lynn Baker, who teaches at the University of Texas Law School. Her scholarly interests are aggregate litigation, group settlements, attorney's fees, and legal ethics. And I encourage you to read everyone's bio on the website, particularly go and read Professor Baker's, because she has a lot going on. Next, we will be joined by Sergio Campos, who is a professor at the University of Miami School of Law. His focus is class actions, as well as aggregate litigation, civil procedure, and federal courts. And then finally, we will hear from Andrew Brott, who you've also heard from, who, as Anne mentioned, is a professor of Berkeley Law and the faculty director of the Civil Justice Research Initiative. And his interests are civil procedure, conflict of laws, and remedies. In other words, we have a panel of civil procedure nerds for all of you today. And I'm going to turn it over to Professor Engstrom to ask her to give us a bit of an overview of what we're going to be talking about today.
Great. Thank you so much, Jocelyn. I'm hoping you can see me and see my slides. That's the goal, at least. And we've heard a great deal about issues of diversity in MDLs, and our charge is to consider the selection of leadership in light of other litigation considerations other than just solely diversity. So in my time, I'm going to try to shine a light on a couple of seemingly simple questions, which will hopefully get us started and lay the groundwork for my co-panelists' remarks. So these are, who does the MDL leadership represent? And beyond diversity, other questions and controversies. So first, the question of is, who does MDL, we've heard all about this MDL leadership. Who exactly do these men and women represent? And I'm going to just, for simplicity purposes, call these folks in leadership the PSC. And I teach a legal ethics class at Stanford where we focus a lot on MDLs. And I start my unit by noting that this is the traditional view or conception of the attorney-client relationship. I like this kind of quote. It's a little exaggerated, but it underscores the familiar perspective that a lawyer's fidelity and loyalty runs hard and fast to the client. MDLs clearly change that, but how far and to what effect is a bit murky. So it's pretty clear that, as we heard in the last panel, when it comes to the defendant's side, the defendant's lawyer still fits the traditional mold or pretty close. Defendants pick their counsel. Defendants' counsel's loyalties are not divided or shared. But can the same question or can the same point be said of plaintiff's counsel? So who exactly does the PSC represent? The manual says this about it: counsel designated by the court also assume a responsibility to the court and an obligation to act fairly, efficiently, and economically in the interest of all parties and parties' counsel. This is kind of a marble-mouthed view, far cry from the traditional conception. What do lawyers say about it? A lawyer in the FenFen MDL put it this way: who do we represent? We represent the situation. Again, pretty sharp deviation from the traditional conception. And of course, here it's doubly unclear because lawyers in the PSC typically have their own clients to whom they do presumably own traditional non-diluted duties and loyalties. And so the question then becomes whether these traditionally retained clients are somehow of a lesser or somehow of a greater obligation relationship to the general group of clients, where maybe a secondary status is owed or secondary loyalties are owed. Compounding all this, as I think Lynn Baker is going to talk about, some PSC members, as in Roundup, seek fees not just from clients within the MDL, who they do represent, but also from those in state court or with unfiled claims, suggesting logically that MDL leadership members represent clients outside of the MDL, which too is hardly self-evident. So the bottom line here is that MDL leadership is really important. Figuring out who is going to take the reins is really important, but also figuring out exactly what their charge is critical. And at the moment, I think it is too squishy. Our answers are too hard to come by. Now, the second prong of my remarks is, beyond diversity, what are some other brewing controversies? So there's not just the question of who does the PSC represent, there's the question of who gets to serve in the first place. This is what we talked about in part in the last panel. And this is a big question in part because, unlike Rule 23, which really sets forth what it is that judges must consider or may consider, the MDL statute is comparatively quiet. So who gets tapped? In the last panel, we heard about one side of controversy, which is gender and racial diversity. For a long time, MDL leadership has been strikingly undiverse, which is a big problem. We saw some of these statistics in the last panel. Beyond that, I want to flag 3 additional sites of controversy that bear on this who gets tapped question. The first is case counts. Should it matter whether the lawyer vying for a spot on the PSC has lots of clients, lots of individually retained clients? The answer is not totally clear. On one hand, the answer is it should matter, and we want lawyers with lots of clients. We have a contingency fueled incentive here to maximize case value. If a lawyer is appointed without clients, as for example, Melvin Weiss was appointed in Zyprexa, although he had no clients, in that case, the lawyer's payment depends wholly, entirely on common benefit fees and perhaps the lawyer's relationship to the appointing judge. And the lawyer could work to appease the judge at the expense of the clients. That does not seem to be a good thing. On the other hand, if we start creating anything like a presumption that lawyers with the largest client inventories are the ones who get the nod, that of course creates this perverse incentive to grow client inventories, which Jack Weinstein famously called the vacuum cleaner effect. You suck up as many cases as you can, irrespective of case quality. You bring in cases of dubious merit, and that too is hardly a good. Second site of controversy is just how much of a role fellow lawyers should have in the selection of MDL leadership. On the one hand, it seems like lawyers should have a big say, in part because specialized members of the bar are more likely to know the reputation of their fellow litigators, particularly than an out-of-state judge, and particularly when it comes to things that are hard to discern from the outside, things like collegiality and work ethic. Also, fellow lawyers working on a contingency fee are apt to promote colleagues who are apt to be aggressive and dogged. If judges picked, we are worried that judges themselves who might want a quick settlement might be tempted to select lawyers who might be insufficiently tenacious and too quick to compromise. On the other hand, there's this worry that if lawyers pick their own slates, that just perpetuates the good old boy network that we heard about in the last panel. We're also worried that lawyers are going to engage in ugly horse trading or back scratching. The manual nods to this concern, nods to this issue, but hardly resolves it. The third issue is this issue that we heard about some in the last panel of repeat play. When it comes to MDL leadership, should we prioritize experience or new blood? So some, including those we heard of in the last panel, advocate the latter. They look to the fact that MDL leadership positions currently very often feature the same cast of characters, and they see a real problem with that. Others, including Andrew Bratt, who we'll hear from in this panel, look at the same information and see something that is salutary.
Thank you. Sorry, thank you, Professor Engstrom. Let me turn it over to Judge Dow now.
Okay, I hit. So thank you, everybody. I'm very happy to be here. The title in the outline for my part of this panel was View from the Bench, but in truth, I should be honest that my views on MDLs are much more colored by my time on the Rules Committee than on the 4 MDLs that have been assigned to me, none of which have had more than 30 cases in them, because all the attention in mega MDLs, and probably deservedly so to some extent, given the statistics that Anne opened the program with, that there are 50% of all the cases in the system are in MDLs, and most of them are in those MDLs that you've already heard about and that you'll hear some more about in the next few minutes. I just wanted to raise 3 points today that I think should dovetail nicely with what's previously been said and what will be said within the hour. The first thing I wanted to talk about was picking up on Judge Caldwell's points, but others have made these as well, and Nora just made some of her remarks as well, that those of us on the Rules Committee who are considering proposed amendments are very well aware of the trend, both by the JPML to expand the pool, and then the transferee judges themselves are also very consciously expanding the pool of lawyers who are appointed to steering committees and other important roles in managing these MDLs. And I know that Professor Brandt is going to speak later about the benefits of repeat players. And he makes a lot of good points, so many good points. Actually, both of the articles that Professor are assigned reading in the complex litigation course that Judge St. Eve and I teach at Northwestern. But there are also advantages to bringing in new and diverse lawyers and judges, and in giving promotions to lawyers who in prior MDLs and are clearly ready to take on bigger roles in new MDLs. One of the questions that this trend, both on the judge side and on the lawyer side, and to be honest with you, it's more on the judge side that I think the Rules Committee is worried about. We know that people who have been second and third chairs in MDLs are very well versed in MDLs by the time they get that first chair responsibility. But not all judges have experience in MDLs. In fact, many don't based on their practices. And if you were an assistant U.S. attorney for 20 years before you went on the bench, you may never have seen an MDL before, but the JPL that
Judge Dow, we've lost your audio.
Am I back? Better? Okay, good. Thank you. Sorry about that. I'm not, where did you lose me?
Just about 30 seconds ago.
Okay, well, I guess I'll go back to saying that the Rules Committee is thinking about whether to perhaps propose some amendments to Rules 16 or 26 that, or both, that would prompt new judges and perhaps new litigants, although it's much more likely the judge might not be aware of what some of the best practices and initial case management techniques that ought to be considered at the outset of an MDL. One of those examples was referenced earlier, and that's this initial census idea that has been used in Joule and in 3M and in and it's really an idea that Judge Fallon refers to this as the first page of a plaintiff's fact sheet. And it's just having the lawyers work together to develop a census. And so the judge can get her hands around this massive monstrosity that's been dropped in her lap by the JPML. And I think Judge Rosenberg would say that helpful in your initial appointment order for your leadership team, because it's much easier to have an intelligent appraisal of what needs to be done if you actually understand the case a little bit better than you might have if you had jumped before you had the census done. My second point is related. So in studying some of the larger MDLs, I've come to appreciate the need for transferee judges to think around the corners when they're doing their initial appointment orders and their initial case management orders, because you have no idea how these cases are going to evolve over time. Many of them lead to settlements, some of them lead to bellwether trials. They're very different animals, so you need flexibility. But in the bigger ones, you really need to have some separation of responsibilities. You can't possibly have 200 or 500 lawyers come in and make motions, or coordinate depositions, or speak in court. You have to put some limits. But every case that's centralized in an MDL has its own individual lawyers to start, and all those people have clients. And when a judge says certain lawyers in position or are in charge of managing this or that aspect of a case, that order is necessarily also saying that other lawyers cannot. And what the Rules Committee is focusing on is how do those represent their clients at every stage of the litigation? And does the judge have some kind of responsibility to make sure that information trickles down to every lawyer in the case, that if there are settlement possibilities, that there's a process that's fair so people can understand that and explain it to their clients? There have been some proposals to import some of Rule 23, this situation. so that we can be sure that everybody, no matter how far your lawyer is from the locus of power, you're adequately represented in an MDL. And another question, and this goes to something that
I think we've lost you again, Judge Dow.
I think the problem is on Judge Dow's end at this point. So sorry. I think I'm going to suggest that we move forward and come back. Thank you.
Okay, so yeah, we're having a hard time hearing you. Judge, why don't I turn it over to Lynn, and we will circle back at our discussion point. Thanks.
Okay. Sure.
Well, I want to pick up with the topic of settlement that Judge Dow mentioned briefly, and I'm going to be discussing the product liability, the big MDLs that have primarily been the topic of our discussion today. And I want to make just a couple of points that bear on the selection of MDL leadership. The first one of these is that although, as Judge Dow has suggested, things like the plaintiff fact sheet and early censuses that might be conducted by the MDL leadership will ultimately help set the stage for any potential bellwether trials and any eventual settlements. The actual resolution of most large MDLs is almost never a single global settlement that is negotiated by the leadership themselves. This is a common misconception in a fair amount of the academic literature, which is understandable when one considers that those are the only settlements that are not confidential. And so all of the many inventory settlements, and by this I mean, by the way, inventories of claims, not inventories of people, which I agree is not an appropriate way to discuss clients, but any particular law firm or group of firms will be separately and confidentially ultimately resolving its claims in light of the discovery, in light of any trials, whether in the MDL court or in other state courts that may have taken place to date. This means that the role of the MDL leadership is primarily going to be focused on setting the stage for, not actually negotiating the eventual resolution of those claims. It's not to say that MDL leadership shouldn't have experience in settlement. Rather, it's to suggest that almost any MDL lawyer likely will have been involved in negotiating some inventory settlement at some point for his or her own firm. A second issue that is connected with this goes to leadership compensation. And this became a very important topic this summer in the Roundup litigation, in particular when Judge Chabria issued his order, which is available in these materials. And he was being asked by the leadership in Roundup about finalizing the terms of the MDL assessment, which is, of course, how the leadership attorneys are paid. There is no separate fund available for the last several decades. It is through an assessment that the MDL attorneys are paid for their time. And he concluded not only that Judge Dow's committee had work to do in terms of looking at potential rules that might be provided for adding some what he called order and predictability to the attorney compensation side of things. But he also determined that he didn't feel that he had the authority, and he did a very scholarly review of the precedent in this area, and he concluded that he didn't believe he had the authority to levy an assessment on any cases that were not, quote, in the MDL. Now, this is enormously important because of something else that Judge Dow and also Nora mentioned in her remarks, which is the case counts are not what one might think. If one reads the newspapers about Roundup, for example, 125,000 claims supposedly are out there in the world. And indeed, if one looks at the JPML statistics, which Judge Caldwell also spoke about in the first panel, it turns out that only 4,079 cases have ever been in the Roundup MDL. And although supposedly tens of thousands of Roundup cases have since been resolved, the JPML statistics indicate that 200 cases have been resolved. So there's an enormous disconnect here. Lots of cases are never filed, and I should add that the defendants are fine with that. The plaintiffs' attorneys are happy to put cases on tolling agreements. They don't have to pay filing fees. Defense counsel's happy to have the number of actual cases be somewhat vague and unspecified. But this is critical for any eventual payment of the leadership attorneys down the road. Judge Chabria, I think, has started a very important conversation with implications for this entire MDL selection process because it impacts the back end. How are MDL leadership attorneys going to be paid if there are 125,000 cases, but only 3,000 or 4,000 of them can be assessed a fee to compensate the MDL attorneys? And I think that there are a couple of ways that this conversation might proceed, and that the judges, including Judge Dow's very important committee, might come to think about this. One fact that's very clear is these attorneys must be paid. There must be leadership on the plaintiff side, and as the opioid litigation is showing us, also on the defense side, although less commonly. And those leadership attorneys will need to be compensated if the best, or even almost the best attorneys, consider these jobs to be attractive. Perhaps there are alternate ways for them to be paid. Judge Chabria suggested, well, perhaps they could simply charge attorneys who want to use the confidential work product. I'm not sure there's going to be sufficient demand for that confidential work product to really reimburse these attorneys, given the enormity of the expense that's incurred and the time that's incurred in preparing a litigation to the point where cases can be settled. It is the case, and Judge Chabria mentions this, and there's one question in the chat about this. It is the case, it's common knowledge that these inventory settlements that are negotiated do by and large result in higher, what I will call per case averages for leadership's cases than will be true for non-leadership cases. Now, there's a confound of what that actually reflects. If the leadership are also some of the most threatening trial lawyers in terms of their potential to bankrupt a company, it's not so much that they're holding the leadership position, it's who they are and the threat that they separately represent for the defendant that would cause the defendant to be willing to pay them potentially more, and will cause them to feel that they have more leverage in settlement negotiations. Finally, and a very important point that's raised by Judge Chabria's order is who is in the MDL? Who is an MDL plaintiff to begin with? And just as Nora started us off with, who do the MDL lawyers represent? This is no less complex a question, and Judge Chabria devotes several pages of his very thoughtful and very scholarly order to talking about this. So one consideration for the future is if Judge Chabria has now raised questions that other MDL judges consider also to be important, we are going to have to find a way to compensate leadership. And if we're not going to provide substantial financial disincentives for attorneys, good attorneys, to want to play that role. I'll stop there.
Thank you so much, Professor Baker. Judge, let me get it back to you because I understand your audio is fixed. You've got a couple more minutes, so take that if you'd like to just finish up.
Okay, good. All right, excellent. Actually, that worked out perfectly because Lynn completely set up my next point by going through. Point is the other thing that's on my mind, at least for the Rules Committee to think about in whether to propose any amendments, and that's this tension between innovation and authority. And Judge Chabria talks a lot about this in his opinion. He says, well, the lawyers are asking me to do something, but I'm not sure I can do it. What's my source of authority? And I think we all agree that there has to be flexibility for MDL judges, and that MDLs, because there's so many cases that need to be resolved, and there's no reason that we put Rule 1 on hold just because it's an MDL. We're still trying to do just be inexpensive. It's just the scale may cause those terms to have a different shelf life, but we're still trying to do it in ways that are efficient. And the MDLs really are laboratories of great innovation. But sometimes that raises the question, is there authority for this innovation? Judge Chabria talked a lot about that in his opinion. I know the Sixth Circuit talks about that on the negotiation class, which is the brainchild of two of the people who thought most about this topics in the history of the world, yet it wasn't authorized, said the Sixth Circuit. And that's one thing we're thinking about on the Rules Committee, is we understand there has to be flexibility, but we're also concerned that if judges need to do something in MDLs for which their authority is questionable or perhaps non-existent, ought the rules authorize that? And are there certain things that our judges are doing in MDLs that maybe are a bridge too far? And is that something the rules ought to think about as well? Because we want to make sure that when judges do things that we all would endorse, we don't want anyone to come in and say, well, that can't happen because it's unauthorized. And on the other hand, when judges go too far, maybe we ought to be saying that is too far. So that's the last topic I wanted to raise, and Judge Chabria talked about that a lot, and Lynn set it up perfectly for me. So perhaps the pause in my microphone was actually a good sign, but thank you.
Yes, we look for gratitude in the smallest things these days. Let me turn it over to Professor Campos.
Thank you, Jocelyn, and thank you all for allowing me to participate. I really want to sort of build on a lot of the points that were made, some by Nora, some by Judge Dow, and particularly the points made by Lynn Baker with respect to the selection of lead counsel, which is the main focus of this particular event and this particular panel. I'm very sympathetic to trying to diversify the selection of lead counsel in MDLs. However, I do want to make a point that's almost kind of like a reminder with respect to why we have these type of aggregate procedures like class actions, like MDLs, in which we are doing something like imposing lead counsel or a class attorney or a representative type attorney and compensating them in such a way to provide common benefit work. Now, I benefited Judge Chabria's opinion with respect to the motion for the holdback. It is very scholarly and it covers a lot of ground. And I want to use one statement he makes in his order as sort of a jumping off point. In discussing the holdback order, he sort of says, he does say, there's nothing inherently wrong with lawyers, and by extension, their clients benefiting from the work of other lawyers without paying them. Later in the order, he sort of expresses some concern with extending the powers of a district court in an MDL in order to make sure that attorneys are paid for common benefit work, and sort of questioning why we have to go to such great lengths in order to make sure that people are not free riding. And there actually is a justification for why we want to make sure that attorneys that do common benefit work are actually compensated to the maximum extent possible. And this has to do with the inherent nature of these types of cases that go into MDLs in the first place. Cases that are selected for MDLs, just like cases that are suitable for class actions, typically involve a single defendant against multiple plaintiffs, all who share a common issue, typically common issues of liability against that defendant. And so here you have a many against one situation. This is sort of the classic analytic structure of all the cases that you tend to see in MDLs. And so we tend to focus a lot on the plaintiffs, but the reason why we have procedures that allow for the selection of something like lead counsel has to do with an inherent advantage that the defendant has that really shouldn't be lost. And here's this advantage. Typically, we assume that the parties in these types of cases, and this assumption is extremely accurate because many of the companies, like in the Roundup litigation, Monsanto is an entirely large, well-capitalized company, makes rational decisions. A lot of the attorneys on the other side also make rational decisions. And there's a concern, an overriding concern, that the claims are developed in such a way that we get the maximum return on investment with respect to each plaintiff's recovery. It's really important. So if you have common issues, from the defendant's perspective, they're going to invest in those common issues to the extent that they're going to be concerned with the total liability associated with those common issues. This is going to be true regardless of how the plaintiffs are organized. For example, if the plaintiffs are coming one by one, the defendants are not going to invest with just the amount of recovery at issue in any specific case. They're going to be looking ahead to future cases that are going to be coming. If the plaintiffs are coming as a class action, defendants are going to invest in much the same way. If the plaintiffs are organized in an MDL, if the plaintiffs are organized in voluntary aggregation sort of association units, no matter how the plaintiffs are organized, defendants are always going to invest in common issues as if they are facing a class action. And so because the amount of liability in the aggregate is so immense, defendants are going to inherently invest an incredible amount of resources with respect to those common issues. That is the structural disadvantage that plaintiffs face. Because many plaintiffs in these cases have recoveries that do justify at least the filing of the lawsuit, they don't have enough at stake that would rationally allow them to invest the amount of resources into common issues that the defendant naturally has, because the defendant is in a naturally aggregated class action posture. That's why you need lead counsel, and that is why you have to compensate them properly, and that's why there is, in fact, an obsession with respect to common benefit work. There is a perception, you get the sense when you read Judge Chabria's opinion, that there is some sort of minimum adequate amount that would be okay in order to make lead counsel responsibilities worth an attorney's while. But I think that mistakes really what's going on here, because it's not so much that you need to reach some sort of minimum adequate level. What you're really concerned with is that the defendant is always going to be at the maximum possible level, because the defendant is always going to face the total liability associated with that common issue. Ideally, and it's in some academics, such as Brian Fitzpatrick, suggested that we should just give, in some small claims class actions, the entire recovery to the plaintiff, in which case the incentives would be exactly the same. But because we use litigation for compensation purposes, this is probably not an ideal solution. A better solution, I think, is to actually enforce something like holdback orders that not only reach the cases that are litigated within the MDL, but also reach other cases that are outside of it, because all of the plaintiffs benefit from the investments made by lead counsel. And moreover, if you were to set up the incentives properly, doing it from the beginning, then that would provide the adequate incentive for lead counsel to invest in these types of issues, and everyone benefits from this. I think sometimes this point gets lost, but I think it's really important to recognize that in all of these cases, this inherent advantage that the defendant has with respect to incentives to invest in common issues. And it is for that reason that we should support compensating common benefit work as much as possible. Thank you.
Great. Professor Brott, take it from here.
Okay, thank you. Thank you very much. So it's really, again, a pleasure to be here with so many of you. One of the perils of being last after such a great lineup is that there's so much I want to agree with and some stuff I want to react to as well. But hopefully without being too repetitive, I wanted to, as Nora foreshadowed, use my time to note some of the important benefits related to appointing at least some repeat players in leadership positions in MDLs. Now, in so doing, I don't want to diminish the risks that are involved with repeat players, some of which that Beth and Margie alluded to in the first panel today. Those are real, and those criticisms that are so prominent in academia are no doubt important. And there are no doubt serious agency issues that arise between any lawyer that operates both in a capacity for a group and also for individuals within that group. I also don't want to diminish the importance of diversifying the pool of MDL judges and lawyers. That also is important. But I also don't want the balance of the debate to get entirely out of whack. Repeat players, as I think is probably clear, are never going to go away on the defense side. I think Margie's statistics that she noted earlier make that clear. Mark Galanter probably taught us that 40 years ago. And as Lynn's new Texas colleague, Teddy Rave, and I have written recently, if you're headed into the lion's den, it's probably best to bring a lion of your own with you. Now, steering committees in MDLs have been with us since the very beginning. But unlike many of the judicial innovations that inspired what judges did to deal with the nationwide electrical equipment price fixing litigation that was the immediate cause of the MDL statute, steering committees were the invention not of the judges, but of the lawyers. The lawyers in those cases organized themselves because they recognized that pooling their resources, acting as a team, and deputizing the most experienced lawyers among them would give them the best shot against literally all of the top law firms in the country, which were representing the likes of General Electric and Westinghouse. And so that impulse, old though it is, I think remains equally important today, particularly as some plaintiffs' law firms have become much larger and more scaled up in order to take on some of those same firms that remain prominent on the defense side. Moreover, I fear that a single-minded approach on the potential costs of repeat players provides some ammunition for those who support reforms of the MDL process that might actually make life more difficult for plaintiffs, regardless of who represents them, such as requiring early proof of claims, caps on recovery, or I agree with Sergio about restrictions on fees for common benefit work. Defendants are, of course, perfectly free to make arguments to those who have the power to change the law, but I think it's also important to bring some balance to the debate so arguments intended to make things better for individual plaintiffs don't ultimately get used against them. Now, this dynamic also plays up one of the other important benefits of repeat players, and another one that Mark Galanter foreshadowed long ago, and that's the ability of repeat players to play the long game. Or as he calls it, play for rules by seeing the whole field, making trade-offs both within and without individual MDLs, and in order to level the playing field, especially as the fronts for wars over MDL practice have expanded beyond individual courtrooms and into the halls of Congress and in the Rules Committee. There needs to be a balance of power on both sides. So then the question becomes, how do we try to achieve some of the benefits that I think we all would agree the repeat players bring, while hopefully minimizing the risks of some of the agency problems, while also widening the pool of MDL attorneys so there could be a more diverse set of future powerful repeat players. Now, as Teddy and I have noted, we think that what repeat players bring to the table, aside from expertise, resources, and the ability to play the long game, is the ability to maximize the value of the entire group of the plaintiff's claims. And indeed, Teddy and I have argued that some, though not all, of the closure provisions in the settlements that Beth and Margie described earlier actually may work to plaintiffs' benefit by maximizing the value of the piece that they have to sell to the defendants. but it only works if they're able to do so collectively. So on the whole, we think that cooperation marginally might be better than competition among plaintiffs' lawyers in some of these cases, because such cooperation is necessary to maximizing the outcome for the group. Too much competition can lead to breaks that could eventually be harmful to the group. So the kinds of inventory settlements that happen outside the MDL that Lynn described are a possibility in that sense. Indeed, the inventory settlements in Roundup were a major obstacle to Judge Chabria's approval of the proposed class settlement in that case. Now, whether one thinks he should have or he shouldn't have approved the class settlement, I respectfully disagree with his conclusions there. The fact remains that it remains a significant obstacle. Finally, with respect to repeat players and arguably their greatest strength, we have to recognize that that greatest strength might be the ability to make trade-offs in order to maximize value to the group. That ability can create the greatest risk for individual plaintiffs within the group. So what Teddy and I have long called MDL split personality facilitates that possibility. That is, MDL's ability to function as a group litigation, even though it's formally structured as a temporary arranged marriage of individual cases, facilitates much of the benefit of aggregate litigation while avoiding some of the more formal due process pitfalls that we see in class actions. But we think the most promising strategy for protecting plaintiffs in these circumstances, and which happens to also increase potentially the diversity of leadership groups, is increased judicial supervision as the litigation moves forward. Now, the Manual for Complex Litigation describes many tools for this, and innovations like many of those proposed by some on this panel are certainly welcome. I'm in strong agreement that involvement and supervision of the MDL judge is necessary. Administrative appeal processes that are increasingly becoming prominent in mass settlements can lead to enhanced participation. But as Judge Rosenthal is fond of saying, when she gets the MDL airborne, she really needs experienced lawyers to help bring the plane down safely. Finally, I just wanted to say a word about Judge Dow's most recent comments about potential rule amendments. I think I agree with him. I know I agree with him that one of MDL's greatest virtues is the flexibility that it offers. As many of you have heard me say before, this is a central feature of the statute that was baked in by its creators. So I think this flexibility has to be preserved in general, but also when it comes to selection of leadership and its supervision. Now, everybody agrees with the obvious point that that the federal rules of civil procedure apply to MDLs. The challenging question is to what degree the rules allow judges to recognize what's obvious, which is that an MDL is different from an individual case. That's a problem that I think requires a lot of examination. But I'll close by saying that I don't think that hemming MDL judges in is the right way forward. Thank you.
Thank you, Professor Brott. Before I take some questions, was there anything that anyone wanted to react to in terms of what our panelists have said? Okay, we have some great questions. Professor Marcus has teed up a couple of really interesting questions. So he mentions the fact that in states like California, there are sort of MDL type processes at the state level for state cases. And so how does one manage the common benefit when you have a federal court MDL and potentially a state court MDL like proceeding, sort of who trumps who? Anyone want to take that one on? It's sort of the hybrid between our entirely individualized and our consolidated federal MDL.
Lynn, go. I think Lynn should go first.
Well, I was going to give just one example of how this has recently played out. It has been an area of conflict, not so much who should trump, but avoiding double taxation, I'll call it, of cases. And I don't think there's anyone who thinks being taxed twice just because of the lawyer who represents you makes any sense. There are an increasing number of cases that are going through California. I've heard from numerous plaintiffs' lawyers that California is the new forum of choice for a variety of reasons, including speedy trials and a very sort of relaxed, I'll call it Daubert standard, and there's some other reasons. And so recently, many tens of thousands of Escher cases were resolved all through inventory settlements. And those judges do have the ability to impose, and they do impose assessments. And in those cases, there appears to be less of a question of the sort that Judge Chabria raised in terms of which cases are actually in my court, in part because of some of the structure of how cases apparently are filed in California. So I think we're going to continue to see innovation here. And I'm sure Judge Dow may have some views on how all this works as a federal judge.
I would say in my ideal world, and I know that some of these cases are too big and judges are very busy, but in my ideal world, there would already be coordination between the federal and the state judge on this issue, and maybe even a joint hearing on a common benefit where you bring all the people who have authority over all the people who might be either responsible for paying it or want to dip into people's pockets. I've had many joint hearings with judges in California on my own MDL, one of my own MDLs, where there was sort of litigation and settlement going on both tracks. And we would just pipe the judge in California onto our calls. I never sat on her calls, but the magistrate judge in my court did sit on her calls. And that's a way, first of all, you get the lawyers can't tell the judges two different things when they're both there at the same time. And secondly, it might be a way to coordinate this so you can solve the problem of, I don't have authority over these people, but this person does. So that would be my thought, but that's an ideal world. And I know that real litigation isn't always ideal.
So Professor Marcus has another question. He says in Roundup, Judge Chabria said that the direct clients of leadership get better deals than those who are represented by individually represented plaintiff lawyers. He wants to know empirically, is that actually true? And then, of course, should it be, and what role do judges have in terms of regulating that?
I'm happy to speak to that if no one else wants to. So without divulging confidential information, because in Roundup and in most of these are confidential inventory settlements of claims, I would say that it's not per se the leadership denotation that may result in a higher per case average for any particular settlement. Rather, it's trial success. And so it is public knowledge that the first three inventory settlements that were consummated in Roundup were the three lawyers who brought in the three big verdicts. And that makes all sorts of sense from the perspective of the defendant. And these are folks who, if they beat you once, they can probably beat you again. And you'd really like to have them focused on resolving their cases as opposed to teeing up some more. So to the extent there is sometimes some overlap, in Roundup, I believe there was one person, Amy Wagstaff, who was both leadership and trial counsel in one of the early successful trials. It may look like leadership, but what it fundamentally is who has verdicts. And I would say in that regard that having a trial date is another good way to get the attention of the defendant in wanting to talk about perhaps resolving all of your claims.
Great. Would anyone else like to weigh in on this? Andrew.
I just want to echo that in the sense that there's a lot of attention to the selection of leadership, but not as much attention to the selection of trial counsel and bellwether trials. We talk a lot about how do we select the plaintiffs. We don't talk a lot as much about how to select the counsel. And I think that's a worthwhile next stage of thinking about everything that we've talked about this afternoon. Thanks.
I'll just chime in too to say I think that really dovetails with Andrew's prior points, which is, Andrew's saying there's value in experience, there's value in being a real specialist here. We see that in other areas of litigation. There's really good evidence, for example, that specialized personal injury lawyers, to the extent we can try to hold counsel or things constant, they actually get better outcomes for their clients in regular kind of cases. There's really good evidence of this in the Supreme Court bar, holding different kinds of cases constant. Really, the experienced Supreme Court advocates obtain measurably better results for clients. So it's just no surprise that it's true in the mass tort context. And we see, whether it's in the trial or whether it's in the folks who are really good at taking these cases and organizing them and moving them forward. So I do think that this kind of reality that certain lawyers achieve really good results for their clients shouldn't come as a surprise and does have implications for the kind of Beth Birch versus Andrew debate.
It seems like also this dovetails, Professor Campos, with what you were talking about, which is the entire plaintiff's bar wants to have the best trial lawyer who also has the best case taking the bellwether, right?
Right, and based on sort of like a limited experience, talking with lawyers that do a lot of MDLs as well as judges, like Judge Proctor, for example, my gut sense with respect to the selection of trial counsel, at least on this point, that there's a lot of backroom coordination with respect to making sure that the best trial team is doing that bellwether trial. But I don't. This is sort of more of a hunch than anything else. But this is precisely the kind of coordination you want because the defendant is already coordinated.
And why don't you talk about just sort of how bellwethers do the judges select them? Sort of what's the process for deciding what the bellwether cases will be?
I'll just say, I don't know that there's a according to Hoyle way to do it. I think that different judges do it different ways, and it depends quite a lot on the case. Some judges are more interested in taking control of that process, while I've also seen judges more willing to allow the parties to stipulate to a process. So I don't think that there is a predetermined way to do it. Consistent with my own priors, my view is that judges shouldn't have to follow a paint by numbers process in order to figure out how to do it. But I think there's a lot to be learned now that we have a pretty long track record of bellwethers being a major part of an almost expected denouement, if you will, of the MDL process.
I would just add to Andrew's remarks, which I agree with, that the idea of an MDL bellwether process is also a bit too narrow a conception. In Roundup, somewhat in the same time frame, there were state court cases going to trial, and this is some of the coordination issue that Judge Dow was talking about. Sometimes that's the greater concern, is should the state court case go first, should the federal MDL case go first? It doesn't matter. These all create data points, right? These all create information, which in the case of Roundup, Monsanto's 0 for 3. That's an enormous, and there were lots of zeros in those verdicts. And that's very important information as both the defendant and the plaintiff's lawyers attempt to value what these cases are potentially worth at the time of the negotiation of inventory settlements.
Yeah, I would just highlight that I think the state and federal, it is so important to have them moving along side by side. In Vioxx, for example, what I call the bellwethers in the states were very good for plaintiffs. The bellwether in Judge Fallon's court, I think there were 5 of them. They were not good for plaintiffs. It's really important that we have both data points as we try to accurately assess the value of the litigation.
Judge Dow, would you like the last word for us today?
Sure. Thank you. I would just say a little plug for you all experts to pay attention to what the Rules Committee is and they're doing and help us out. The agenda book, I think, was published today, so you can see the latest and greatest of what we're thinking. But it's a transparent process. You're all invited, and everybody on this panel and the one before it is certainly an expert. So I beg you. And you can see from the questions today, because our lead questioner, Professor Marcus, is our reporter, and he's also the lead reporter on that subcommittee. So it's not an accident. We really are interested in what everybody join us on our journey, which has already gone a couple of years and is likely to go a couple more. So thank you.
I think I for all the academics here, Judge Dow, that the work of the subcommittee, your work when you were chair, the continuing work that's being done has been, you're doing an enormous service for the country, particularly as MDLs have grown to become such a large share of the federal docket. So I really thank you for all of your hard work on that.
So we've reached the end of our hour. Anne, are you on with us?
Yes.
Okay.
Thanks so much to everyone for your patience with our technical issues. Thanks to our wonderful, wonderful speakers. Two really fabulous panels. I know I learned a lot. I'm sure the audience did as well. Thanks for the great questions from the audience. I just want to wish everyone a happy weekend and really appreciate you joining us today. Bye-bye.